Welcome to the Domain Name Law Show. We're here every Tuesday. That's noon Pacific, 3 p.m. Eastern. There's three hosts to this show. I'm one of them. My name is Todd Ryan. Let me get closer to this microphone. Almost said the F word. Okay, so it's me, David Michaels, and Jeffrey Neuman. So I'll say hi to my co-host first to David. Hey, David, how's everything going?
Really unmute myself. There we are. Everything's going fine except for my unmute button.
Well, now you got
So
it. And
yeah, it's good
David,
to.
you always had, speaker. He's the co-host for since over 4 years. But we had problems with spaces, so it was easier. I mean, basically, we don't know. But anyway, we're the three co-hosts. I like the way it looks. If you do have a question, I don't know, raise your hand. We may have some time. We try to do it at the end of the show. But if you have a legal question, we'll bump you, through our topics, bump you up to the head of the list. Anyway, my other co-host, Jeffrey Neuman. Hey, Jeff, how's everything going with you?
It's going well. I found my mute button pretty quickly, so we're all good on that front. Um, yeah, lots of cases. Never a lack of UDRP topics to talk about. So I'm ready.
Yeah, and David, I don't know. I'll try to be close to the mic. If you get closer, Jeff, you sound great. There's so much news. I mean, legal news even, and next week we'll probably do a couple cases that I see right now. That ks.com decision, two-letter domain that just came down. And I'll tell you, because you guys won't remember it for next week anyway, but it was a complaint denied RDNH. But anyway, you see people trying to get these valuable domain names. And that was an interesting case, right, Jeff? Because they apparently,
Yeah, that one was fraud. I mean, the complainant was just lying and tried to get the two letters. They didn't even own the trademark. But yeah, so it's a good conversation to have next week.
yeah, and they, Barry Hill, I think, made a good point about, yeah, you don't need to have ID to file a UDRP complaint, but they sure want you to have ID or prove who you are when you register a domain name. But that's interesting in that case. Both the complainant and the respondent were saying, "I own the name. I own the name. Hey, I'm Spider-Man." But anyway, what's happening with any update on your case, Jeff? The one where the non-paying or the non-delivering domain owner?
Um, yeah, you can see from the Whois records that the name has been transferred to our client, so um, all good.
It sounds like you had to go visit somebody in person. I know you came to my door one time. I thought, who in the? I start here's my wallet. Here's everything. Congratulations. That's pretty big. I mean, they paid for it fair and square through escrow, and now it's delivered. Well, anything. So is it basically settled? I mean, is it over? What do you have to do now? Just wrap up some paperwork or what?
Yeah, but we will file a voluntary dismissal. Yeah, and then it's over.
Yeah, other interesting news that I didn't have on our outline. By the way, if you want to check out our outline, go to dnlshow.com/outline. You see, we have, like we do every week, we go over it's usually legal news. If there's not much legal news, and there always is now, it seems like, try to cover, like this week, I'm going to talk about a couple huge domain sales with the guys here. But you can check out our outline. One thing I didn't have on the outline was OpenAI uh, filed a trademark application for GPT, and I guess it was denied again. You guys know anything about that, David? Did you see that? I mean, I haven't. We might talk about it more
I
once we
thought it
look
was
at it.
denied last year. Maybe there was a follow-up and it's still refused. So I haven't followed it, but yeah, I'm not surprised.
Yeah, if anybody wants to check it out, John Berryhill on Twitter, friend of the show. And I will say, okay, so I'll make an announcement right now. At NamesCon this year, we're going to have a fantastic mock hearing, a UDRP hearing. I got to put together the case facts. But anyway, John Berryhill is going to be representing the domain owner in our hearing. Jason Schaefer is going to be representing the complainant. And we got three panelists. And I'll just tell you one of them. He's right here, Jeffrey Neuman, who's a real panelist in real life. So I think Jeff,
I play, yeah, I play one on TV. No,
yeah,
yeah.
but we might have some wigs and some robes and stuff like that. So who knows? We might look younger. I'm just going to be the master of ceremonies in this production, but really look forward to it. But to know, it's going to be fun. We got Jason and John already. That's fun, and then um, there's going to be three of you on the panel, and you're going to decide it like we do a regular case. And I'm going to throw in some fun facts on what case this is going to be, but we'll talk more about that as the time goes on. That's this year NamesCon, November 5th and 6th. If you haven't, signed up to go to the event, it's going to be, sounds like more parties than ever, but great sessions, super location, fun hotel, the whole thing. And plus all these South Florida domainers, I think there's like 30 or 40 of them, the big timers, right? From Rick Schwartz to Mike Mann to, um, well, it's a couple of them I don't even want to talk about. But anyway, I like Mark Daniel a lot. And I really like, of course, my partner, Chad Foken. He's like a brother to me. But all these guys in South Florida, they're like, OGs in the business. But I expect this to be a big event. But anyway, check out namescon.com and sign up. See you there too. And if you wave to me from across the room. If I acknowledge it, that means I want to talk to you and I'll come over there. Just kidding. Say hi when we're there. We're going to have a good time. Jeff, we always do. David doesn't show. David's still not traveling. He starts traveling again. Now I'm assuming once Trump's out of office. but he took a break for a few years because of COVID, so might as well go another few more years. But David, we're going to, you and I cross paths in person soon. I get through Toronto on my way to Europe. I go once every decade. All right, so enough with the bullshit. Any update on your case, Jeff? Okay, I already asked Jeff that. There was, besides what we're going to do next week, before we jump into the legal news, there were some huge sales. I'll just say them real fast. So, David, you mentioned BigCommerce. Okay, so last, I guess it was in February, we saw DN Journal reported that Larry Fisher and Ari Goldberger said, hey, we sold commerce.com for 2.2 million. Well, they didn't say who they sold it to, but BigCommerce, the big Shopify type uh, platform, they I guess filed their whatever their Q1 financials, and somebody saw in there that said they spent 2.444 million on a domain name, and they're assuming this was for commerce.com. We see a lot of name servers changes or whatever, the standard stuff. It's moved to I don't know, a management system. I forget who it was. I didn't write it down. But who does BigCommerce's other name, bigcommerce.com, which I would have just, these are good salesmen, these guys, to get them to buy. Because bigcommerce.com, that's fine. Commerce.com, really, it's very generic name. And now that I brought that up real fast, and David, I hope you have some comments on this because I'm going to shut up. Is this Thursday when Josh and I do this DNX show, and this is about domain investing, so I expect all you guys to be there. Sten Lillestrom is going to be there. He was a guest on this show a couple weeks ago. In interesting here, but it's I think even going to be more interesting when he gives us some of his data and his take on names like this, commerce.com. He thinks thumbs down, like commerce.com. Two, not names that explain exactly what you do aren't the type of names that you want, although most domainers believe it is. And then even some surveys say, yeah, people like to know that the name matches what they're doing. But I'm in the Sten camp. I mean, this guy, Sten and Josh, these are two, at least domain investors that are doing it right today, not guys that bought stuff 20 years ago and want to act like they're big and bad. That's what I do. I bought stuff 20 years ago. Of course, you're lucky. You got stuff a long time ago. But anyway, so join us Thursday morning, 10 a.m. Pacific, 1 p.m. Eastern, DNX show right here on X, because Sten's going to be there. And we're going to talk about names exactly like this, why some people, like BigCommerce, paid $2 million. Dave, what'd you say about this? It's not resolving now, and do you think this was a good purchase
It's not
considering they have?
resolving. The name servers are at safenames.com. I don't think that BigCommerce owns it yet. I think there is another owner currently, or there's a payment plan, but that doesn't make sense because they would change the name servers anyway. Safe Names is definitely not a BigCommerce name server. So I don't know what's going on with it, but BigCommerce would be the best buyer for this name because they spend $160,000 a month on PPC ads just for the term BigCommerce. They don't rank for it, and that's a problem. But if they had a distinctive name, then nobody else could bid on their name. But there are people bidding on trademarks in Google PPC, so that's still a problem, and it's not going to go away because of a Ninth Circuit ruling. So um, that's okay. Sten and I had a disagreement. He thinks that any word can be used arbitrarily for any purpose, and that's not true. He's misguided in that because, sure, the name Apple is not something, it's not selling apples that you can eat, but it represents knowledge and simplicity, and that's what Apple Inc. represents and their products represent. So there's always a feeling that comes from a certain term. So we had a discussion about sprints.com and how a VC firm is using it. And instead of, say, project management company or using agile project management or competing with Jira or something like that, or a food delivery service, they bring it to you quickly. Something like that would make sense for sprints.com, but not a VC management firm. But Sten thinks that, oh, I can use any word arbitrarily. Like, no, that's not how it works. Every word has a meaning, one way or the other.
Well, true, you can say that, but I tend to think, like he says, it might not be a great decision for somebody to use, like you said, sprints for a VC firm. Well, it might be, like you said, well, that doesn't make sense. Well, maybe to you it doesn't make sense. Maybe somebody else has their explanation, and you're thinking, well, that's not going to do well for you in business. But I tend to believe, yeah, commerce can mean a dating site. And you're thinking, well, that doesn't make sense. Well, somebody's going to have their explanation for it. But anyway, the talk, I know, I hope you'll be there on Tuesday. I mean, sorry, Thursday, because it'd be fun. I want you to, we'll bring this up exactly. Especially, I like for you to say to Sten, he's misguided because he's always real. He's very opinionated. He's fantastic in my opinion too. So, and I know you are too, Dave. That'd be a good conversation. And Josh has some thoughts too about. I don't think they don't always fall in line with what Sten thinks, but Sten, then we can get into the data, and he's got. He just, no one spends more time thinking about naming that's a domainer. Now, we had that doctor on the show with him. That guy, that gentleman, obviously spends a lot of time on naming and linguistics, but as a domainer, anyways, it was going to be an interesting show. David, about this Ninth Circuit ruling, what was this ruling had to do with what? What were you saying quickly?
Oh, it was regarding advertising some branded watches on Amazon and whether or not that's trademark infringement. I think the case was from way back in 2011. Anyway, the ruling is there's no confusion. It's initial interest, yes, but it's an ad, and people know it's an ad.
So much to go over today. This is going to be a fun show. We got 3 great cases, but as we get through the news, the second sale I wanted to talk about was Odyssey. We don't know what it sold for. Hilco sold Odyssey for on behalf of Braden Pollock, friend of the show. Okay, Odyssey, yeah, I can spell it when I write it down. Odyssey. We know it's a popular word. It's pretty cool for a brand, I guess. I don't know who's going to be using it. I think they said who picked it up. I don't know. But Braden said it was by far his biggest sale. Well, he has big sales, okay? He's had 7-figure sales. So he says by far this is his biggest, substantially. I'm guessing had to be 5 million, 6 million. His biggest sale before I think was a couple million, but I don't know. I sold Cali soda for $1,988. I don't know. I'm like at the nickel slots and or penny slots. I don't know. I do have a $7,000 deal that's been negotiated and pending payment. I mean, I can't wait to post it. Act like, yeah, I can do this thing too. I do domain sales. All right. So anyway, huge sale, Odyssey, and the only other ones I wanted to bring up. Well, any comments you guys on Odyssey.com? I mean, you think that it's a tough word to spell? Is it worth in the millions?
Well, obviously, to somebody, I know that it was NewCred had it before. They had just like a landing page inquiry here, and then it was just email me here, and then it was Andrew Miller. And apparently this is Braden's biggest deal yet. So what is it? An 8-figure deal? A 9-figure deal? I don't know. Sounds good.
Yeah, Jeff doesn't care. Because he knows, yeah, it is worth it. I mean, right, Jeff? I mean, somebody paid it, so and it's a
Yeah,
super.
I mean, look, hey, we'll see. It's kind of a cool term, cool name for a brand. It is not the easiest thing to spell, but uh, yeah, more power to Braden.
Yeah, Icon sold, and I was looking just in the last month, and just to add to this little story of huge sales, Icon sold for 12 million. Hilco did that one too. So Hilco did Odyssey, and sounds like they did about 20 million. I know they're not doing a lot of their stuff. They do plenty through escrow, but if we read the escrow.com, I'm sure you guys all saw the post. Andrew Rosner and Media Options, 7 years in a row. That's friggin' impressive. I mean, it's just unbelievable. It really is. So it's like a, ass kicker. And he loves to, uh, mix it up a little bit, all in fun, I'm sure, with Andrew Miller and Hilco. But Hilco just did 20 million. Looks to me like in the last month. They did more than that. I mean, these two deals, 12 million. Say the other one's 5. I mean, anyway, they must. I was wondering if what type of escrow they use, and if they maybe use some attorneys as opposed to escrow.com, because I didn't see Andrew Miller or Hilco in the top 10 and they were number 2 last year, because I remember we were at NamesCon. They were giving Media Options some awards. But very interesting. These guys, $1 million stuff happening. And one thing we will be talking about in the domain investing show on Thursday is Drew over at Media Options is saying, boy, it's hotter than ever. These next 12 to 24 months, you're going to see more sales. It's time for domains once again. They're going to be in the light. But then, David, I'm sure you notice on here on X, there's a lot of people very disappointed. They're having their most worst times in the domain investing space, meaning the lowest sales they've had in years. And I see people, boy, they get mad at Afternic. I'm going to be nice with them because I think I might try to get them as a sponsor on the show. Anyway, people get pissed at Afternic when they don't make any sales, and I think a lot of people are hurting them. But the high end, we saw mine.com sell for 680,000, and then I'll just say Rush.ai sold for 300,000 on Atom. So these were all in the last month. So it's fun to hear about these big sales. If you don't own a single word, you're probably not going to get hundreds of thousands, definitely not millions. All right, the next thing on our outline, I'm sure, had to do with new gTLDs. Jeff, I wrote down a few notes. Basically, by the end of this month, some things happen. We're talking now about ICANN's next round of new gTLDs. Okay, a couple things that are happening is, well, here in May, the big thing is that the guidebook draft version is supposedly ready by the end of this month. So that's just going to be the draft of the guidebook. And then, Jeff, do they ask for feedback before they get it, the final version in December? What happens after they release this draft version?
Yeah, so it's the final draft, right? Some pieces of it have been put out. I mean, all of it's been put out essentially, but in little blocks, right? So the implementation team, and I'm on that, has been going through all the comments from those different comment periods for different sections. But now it's going to be put out for a final comment period in a full draft. So you'll see what it's going to look like, and it'll be for comment for about 45, maybe 60 days, and then they'll take the feedback and do the final version. Um, I think the goal is to submit the final version by the end of September to the board so that the board could adopt it by the end of the year. Um, the other big thing this month is that um, registry service providers, the back end providers that provide the technical services, On May 20th is the end of the submission period if you want to be evaluated as a technical backend provider prior to the round opening up. Now, the benefit, of course, is that there'll be a list that comes out of all the registry service providers that have been approved. And if you, as an applicant for a string, want to use one of those providers and you're not going to really do anything new technically, you're just going to be a normal everyday registry, then you could just put on your application that, yeah, I'm going to use a pre-approved one, and then you don't need any further technical review on your application. So, you're going to see after, finally when the evaluations actually occur and the submission period closes, you'll see these registries come out of the RSPs come out of the woodwork, um, saying, we've applied, we've been pre-approved, whatever, and they'll all be competing for the back end business, for new registries, that want different strings. So, yeah, there's some deadlines coming up, and the good news is that ICANN has, amazingly met all their deadlines so far, and yeah, so everything's moving full speed ahead.
So the RSP deadline, I know for the pre-evaluation is ending this month. Now,
A week, yeah, in a week,
so
yeah.
so then that it opens back up, meaning then there's they can basically still be evaluated, but it's not. May take some time, and I guess what I'm
Right,
getting at, Jeff, is it may take some time, and then people that are applying, applicants can't really put them on their application as
correct.
here's my approved
Right. So
already.
yeah, the way we designed the program was that, look, anyone can apply to be their own backend provider or, be evaluated at the time of application. But if you want to market yourself prior to, um, you have to submit the application by May 20th. And but it doesn't prevent anyone from, during the application window, from submitting your proposal to be an RSP if you weren't able to apply during the early evaluation.
See, thanks for explaining that. And for those listening, there's an applicant support program too, and that's for applicants who may need some support, maybe financial support or other consultation support. That doesn't close until November 19th, 2025. But I would say if you are new to applying for a gTLD, then you would likely probably want to check out the APS. I'm sorry, the ASP program, um, because there's certain things that you may need some support on, and it's fantastic that they offer the ASP program. But Jeff, I wanted to ask because a friend asked me on X, where are we at with what are people guesstimating? I said it was too early, but I really just hadn't asked you first, and that was how many applicants are we expecting this round as compared to last round, and when does the number really start, heating up, because it's still a year prior to the app window opening.
Look, I mean, anyone who guesses is doing just that. They're guessing. Nobody knows how many are going to be applied for. Last round, people thought there might be 500, maybe 1,000, and there ended up being closer to 2,000. This round, who knows? You've seen some applicants come out of the woodwork saying, well, we're going to apply for 100 of them, or we're going to apply for 200 of them. I think that's what Nova, a new registry, provider, is saying, that they're going to apply for 200. Whether that's an exaggeration or true or not, who knows? So anyone who tells you they know how many applications are going to be is just guessing. Um, and I'd be just guessing if I said I knew. We hope, that there's about the same as last time, but some are predicting lower because of the higher price, and because we now have a round, open round under our belt, and people can see how those registries did or are doing, and make a educated decision or an informed decision, I guess, about whether they want to take the risk and apply, because it's not a given that registries are going to be profitable. And in fact, more strings that were applied for in the last round actually ended up not making much money, if any at all, versus those that did. So are people going to be as optimistic this time around as the last time around? Perhaps, but no way to know.
Well, if anyone listening now or listening on replay, if you or you know someone who plans on applying for a new string in the next round, reach out to Jeff and myself at tldstrategies.com. Just book a meeting. It's a free consultation, but the truth of the matter is you really need to budget properly, as just Jeff just mentioned. So just because it's 200 and say $27,000 is what they're earmarking for, that's the application fee. You're really going to have several other expenses, but you need to get everything, your compliance. There's legal things that you're going to need to consider. You're going to be paying, depending on, even if you do it yourself, but you're likely going to have some help, pay some consulting fees, but there's many other fees that you are likely going to run into. And then you're going to have to show, when we were talking about the RSP, you're going to have to show that you are ready and you have a service provider in mind. Well, that's going to cost money too. The point is, you really need a budget, and that's something that we help folks with. But a budget, even $500,000, is low. That's only going to get you started, because when you operate a registry, what is your plan for the first year, the first few years, up to 5 years, and you really need to understand it's not a small expense. I love, saying it's $250,000 and you can apply. It's really at least double that to get rolling, even, if you, especially if you're successful at winning the string and then getting into your first year. And then, do you plan on doing any marketing? I mean, how do you plan on making your string successful, unless it's just in-house for a brand? And that's still not inexpensive. But I just wanted to say, many times people throw out the number like 227,000 and they think they're going to do something for 300,000. Well, that's just like, you're just getting in. That's the cover charge. Okay. There's all sorts of expenses. There's a resort fee. The drinks are $50 each. Anyway, so if you really, seriously, if you want to, speak about a serious budget and you want to know more specifics about the application process, that's why we, got together with our companies and created tldstrategies.com. So go there and schedule a meeting. Thanks. Um, Quickly, Jeff, about the Hanoi Contracted Party Summit. So once a year, there's 3 meetings a year. Is there 3 ICANN meetings now? They get to 3, or is it still 4?
No, it's three ICANN meetings,
And then one of
but
those,
but
yeah.
separate from that, there is a contracted parties house summit, which by contracting parties they mean the registries and registrars, and so that doesn't technically count as an ICANN meeting, although lots of obviously registries and registrars go to that. I was supposed to go to that, but I got COVID. Yay, me. Um, and so I didn't end up traveling, but I did attend virtually. And it's really a good meeting for if you're a registry or registrar, because you can, outside of the whole ICANN environment, and just talk about issues that are important to registries and registrars. Most of the meetings are completely open, so even if you are not a registry or registrar, you could attend, but there are some closed sessions where registries and registrars talk about specific issues that maybe um, aren't necessarily ones that you want to have outside of registries and registrars. Things that may reveal um, methods or certain methods or procedures that shouldn't really be discussed in public. Um, those are the kind of things. So yeah, that meeting happened last week, and it was in Hanoi. I think next year it'll be in North America somewhere.
Yeah, I went to the one in LA because it was convenient. We went over there and it was I'd say pretty cool. I mean, it is interesting to see the registrars and the registries. They get along a lot and on certain issues, and then they battle on other issues of who's responsible for this with the customer and so on with the domain registrant. But there are very interesting meeting for domain investors, even though not many show up, because you understand the parties involved, and many times you're like, hey, I know that guy. I got a bunch of names over that registrar. But it's always fun to see, anyway, I think what I'm going to do is reach out to a few of our friends that run registries and registrars and see if there's some highlights directly from the horse's mouth on that event. Anyway, that was last week in Hanoi. There is INTA coming up. I know International Trademark Association do that annually, and this year it's in San Diego. I was thinking about going down there just to see all these brand attorneys and go, yeah, let's see, you guys know everything, don't you? But anyway, I know you've been to INTA before. Pretty interesting event, but it's mostly brand attorneys. Is there a lot of folks from the domain space that go there, or not so much, Jeff?
Sorry, so they got a lot of folks that go
I
from the
mean,
brand.
there's domain name lawyers. They battle these brand name lawyers in these UDRPs that we talk about. But at the INTA meeting, is it
Oh yeah,
a lot of domain
yeah.
people or not much?
Um, Not unless they're marketing something to the brand owner. So, like the brand registry group will be there. Um, Lawyers, there's pretty much most of the attorneys that show up at ICANN represent IP owners, so they'll all go. Right, it's the largest meeting every year for IP attorneys. Um, I used to go a lot, but it's not really worth it for me anymore for the expense. But yeah, I mean you'll see a bunch of people, but it usually has about 8-10,000 people attend,
Yeah,
so
big.
it's
Yeah,
pretty big.
yeah. No,
I've
that's
been
a
to about 6 INTA meetings. I met Steve at Safe Names there years
Yep.
ago.
hmm
Um,
He's no
but
longer at Safe Names, but yeah.
okay, so yeah, he's selling domains on his own now. Okay, so yeah, it was bigger before, but now I think since COVID, it's dropped off. They are hurting for money now, but their fees for going to these events are super high. Like
hmm
we're talking thousands of dollars.
Yep.
Unless you get it as a nonprofit, then it's like 250 or 750. But you have to have both the membership and admission tickets, so it's still going to cost you $1,000.
Yeah, the membership alone is like $1,000, and then you pay the member price, which is, as you said, like $1,000. But if you are not a member and want to attend, then you're basically paying closer to 2,000, which essentially is signing up for a membership and the meeting anyway.
Yeah, definitely not
wonderful.
worth it anymore.
Yeah. Hey, David. Since I got you in between sandwiches, hey. Oh yeah, it's late afternoon. You already about this next story on our agenda. I just put it on there because people always like to talk about registering people's individual names. And there's a gentleman, Jeff Burgar. Okay, apparently I was reading different articles about him, but apparently I don't know. Mike Seiger had him on Sherpa years ago, but it was just an audio version. I don't know. I'll ask Mike sometime. But somebody made a comment about it because no one's seen the guy's face, this Jeff Burgar. But he's a domain investor, I think out of Canada. I just brought up some cases that he was part of, basically owned it, but he owns like a lot of people's names. He owned Dave Duchovny. He owned, what were the ones I had down? Yeah, it was
Like
Julie Brown.
Ashley
Oh
Judd
yeah, Ashley
and
Judd,
Julie Brown,
Celine
Celine
Dion.
Dion.
But the thing is, Julie Brown. I mean, that's just silly. That's. I mean, Julie Brown. How many Julie Browns are there? I don't know. 3 million. So he lost that name. I don't know if he was. I can't say. Did the website have Julie Brown? Whoever, which one is which Julie Brown? I know. I already know two of them. One from MTV and another from MTV. They're like two of them. Anyway, and they're not even that famous. They were famous then. Now they're not famous. I have a friend named Julie Brown. More famous than them now. Okay, but the point is, so he, lost Celine Dion in an HVAC case. I was just kidding, in a UDRP case, and he lost those other ones I said: Ashley Judd, David Duchovny, Celine Dion. He did hold on to the famous one, the one back in 2000, 2001, BruceSpringsteen.com, which I always bring up because that was the one where, and he still got, the fan site, I guess, set up there. I haven't went there. But registering domain names with famous people's names, well, David, I mean, is there, people still do it. They're doing it all the time. They do it with the CEO. Is there any reason for it? Is it okay to do?
If you're in the United States, avoid registering anybody else's full name, first and last name, unless it's so common and there is no one person has particular right to it and there's a reason for having it. He won Bruce Springsteen, but that was a UDRP. If it was in federal court, he would have lost, but of course he's in Canada. So then it would go to interim action in Virginia and he would lose there. So it's not worth it if you're in the United States. He gets
There was a reason
sued, you have to
I
pay $50,000.
brought him up because there was an article. There was a recent name. I'll look at it as we're talking because I didn't just bring it up for his own. There's something current that was going on with him, and that's why we brought up those former cases because maybe he lost a new one or somebody's going after him. But anyway, it sounds like he did win a 3-letter. Let me see if I can find that real fast. I had it right here. So, basically he was saying even though he's lost cases in the past, he's a domain investor and he actually had rights. Oh, it's GWG.com. Yeah, it was one. That was all the way back to 2016. All right, it's not that interesting, but he did get that. Last week we had a domain car.cash and it was lost in the UDRP. And I remember friend Charlie, who was the panelist. I haven't had a chance to speak with him since we reviewed the case, but I know that, there's some, issues. I wouldn't, who am I? I didn't think that the decision was correct because mostly, just like with a thing I have on the outline right now, carcashtx.com was lost this past week in the UDRP. So this company, CarCash, is filing, that they got a trademark, Car Cash. They give cash for cars. They appraise cars. You can imagine what they do. Car Cash. It's pretty, they give cash for cars, and like I said, they trade and appraise and all sorts of stuff. But anyway, so they must be aggressive with the UDRP. They won not only the one from last week, car.cash, they won carcashtx.com. And the reason they're winning these is because the respondent's not, answering. And on the website, on both of these websites, it shows the domain name. And the panelists are saying, well, right there, the domain name is they're like last week. It said sponsored by car.cash. Well, they were assuming that the domain, the registrant, was misleading visitors to the site by saying they're affiliated with the trademark holder. No, they were just putting the domain name, like a lot of us know as domain investors. Sometimes you don't do something to a park page and it'll say this page is provided by, and put the domain name in there. So this was a case where Don Osborne, who is notoriously transferring domains away to brand owners who file complaints without much of a, sometimes with hardly any reason. They basically just say the complainant made a case, there was no response, transfer. You guys have any comments on the carcashtx.com case?
Yeah, this guy is an actual car dealer, and he's got photos of his inventory of vehicles for sale, like a Grand Cherokee and an Infiniti, and it's got prices there. He's a car dealer, and you go to him to buy, you sell your car, and he'll sell it. So there's nothing wrong with what he's doing. He's not infringing the trademark. He should hire an attorney and get some ACPA damages. If there ever was a case, this would be it. And I can help him with canceling the car.cash trademark. Sorry, the car cash trademark owners' trademarks. There's a lot of ways. Even if it's incontestable, there's still ways of canceling them. It's never impossible.
Whoa, David's heavy-handed, and we're going to talk about canceling someone else's trademark later on in a case. Except, yeah, that's mean people do stuff like that. I'm just kidding. Smart people sometimes need. Jeff, have you ever canceled had canceled a trademark or been involved in a case where there was a trademark canceled even from you or the other party?
Um, I've certainly been in cases where we threaten to cancel someone, who comes after one of my clients, and then usually you work out a settlement. But I have never had to file a cancellation. Um, Usually the threat uh, scares them enough into entering some sort of agreement for an allowance of my the clients I have to go forward.
Well, great. Well, David, keep your anger near the surface because we're going to talk about canceling trademarks, and I want to ask you, basically process and success. And it seemed like in the case we're going to talk about, somebody filed to cancel a trademark and it got canceled. And anyway, we're going to get back to that. Let me just finish up these news stories. And okay, besides car cash, well, that was just because last week we talked about car.cash, and I thought, geez, well, you need to answer these UDRPs. Friend of the show, Igor Motsnyi, who was a guest a few weeks back, he is a panelist. He represents domain owners, but he also has a few clients, several, I think, that he represents these companies like PaySend, okay? And he'll rep them on the complainant side. So quickly, I just wanted to say he was successful in another UDRP where the domain was pay-send.cash. And you can imagine, he reached out to me and said, Todd, as I mentioned to you before, we don't go after everybody that uses PaySend and pay-send-cash. This is pretty generic, okay? And he's nice enough to give me advice because I'm working, company I founded with Chad, Pay Now. Well, there's dozens, not only dozens of companies, hundreds use Pay Now in their domain name, but they also have brands. I mean, big companies, because a lot of people, you're allowed to use that. And you see when you go out tonight at dinner, it'll say right on the screen, Pay Now. But the point is, Pay Send, very common phrase as well. So Igor said the reason, we don't go after everyone. In this case, pay-send.cash, the people were using PaySend, who is a company that, offers credit cards, allows people to, send money to others via cards and other methods too, but said they're using our trademark. You go to the website, they're using some of our, our artwork, basically look like a trademark and a copyright, a bunch of infringement there. And in those obvious cases, that's when we protect ourselves. But he basically was letting me know, they're aware too of the that people are allowed to use these generic terms, pay send, and it's just when you cross the line, um, I think this is what the UDRP was made for. You registered it after your mark, impersonating you, that was what I consider a clear cut case. But just brought it up because I wanted to say shout out to Igor and say, interesting case. Sometimes you got to protect yourself, even when you have a mark that sometimes people consider tough to protect. Any comments from you two?
Yeah, I mean, I think you're right. When you go to the decision, you always have to look. You don't just look at the domain name in question. You look at the decision, and the decision certainly is clear that it implies endorsement by Igor's client because it links directly to Igor's client, and one who visits this domain name could easily believe that this is affiliated with Igor's company, and um, so that's a sure way to lose a case like this, or in Igor's case, a sure way to win.
Yeah. Yeah, yep. David, did you see that at all? Any comment? You're just ready to.
Yeah, I didn't go into detail, but yeah, you don't go filing UDRPs unless there's actual infringement or there's a reason for it. Otherwise, you're going to get stung one day.
We're about ready to get to our cases right now that we review 3 UDRP cases. I still had the link from last week about Gigalaw, had a domain digest. Pretty interesting if you're interested in the numbers on domain disputes. Are there more UDRPs than last year at this time? And then more data on them, like what extensions and so on. So I got that link there, but you can check it out. Finally, I wanted to say, I believe it's the 28th. I'm going to have to check real fast. It's B7 on our outline. B7. That's certainly a bingo there. Oh yeah, May 28th. Looks like it's going to be 8:15 a.m. my time. Okay, so there's a WIPO ICA report webinar, and it's basically insights into the UDRP reform. Zach Muscovich and Brian Beckham from WIPO are hosting it. They're going to, I suspect, give a presentation and then maybe have some questions answered. But so check that out, that link. And before we get into our case, I wanted to tell you, Jeff, or say to you, or ask you, yeah, so, everybody's talking about UDRP reform, and we were going to do, after we go through, through this, I'm going to go ahead and let them have their webinar. But then I wanted to have a panel here on the Domain Name Law Show. Thought we might do it in May, but we'll wait until June. Because it's got a lot of guys from, Nat Cohen to John Berryhill to Steve Levy, but Igor, of course, you and me and David talk about UDRP reform. And really, is anything going to get done? Because people talk about it, but this appeal mechanism. I was thinking more of like, I've been watching these NBA playoff games, and I'm thinking more of just a challenge. You got a bad decision, you can challenge it. They don't take all the time like a big appeal, like in courts, we're going to appeal, it's a whole new case, and we're going to submit just maybe a challenge. So that's my new thing. Instead of an appeal mechanism, there just need to be some kind of challenge to the decision that can be overlooked by, still a team of people, a few people, but to make a quick decision like, yes, your challenge is successful or not. What do you think about a challenge to a decision, Jeff?
Well, that is an appeal. I mean, whatever you want to call it. But I would say I would just amend your statement. You said everybody's talking about UDRP reform. Well, everybody except the people that can actually effectuate reform, which is ICANN. And specifically the GNSO Council, who this Thursday, will vote on deferring review for another 6 months, right? So I think it's great that these discussions are happening. But what I think is that it's not happening where it's supposed to happen, and that's at ICANN. And it's primarily because most IP owners don't want any changes, or they're happy with the way it is. They're afraid of what changes might be made that's not in their favor. And the other groups are they just don't care, right? Registries and registrars like the UDRP the way it is because it protects them from liability, which is one of the main reasons the UDRP was created, right? Is so that you don't go after the registry or registrar for contributory liability. So registries and registrars aren't going to take the initiative to start the review because, the IP owners really are the ones that it affects. The non-commercials, well, they're just not organized enough, nor are they interested enough in that subject, right? Privacy is their big deal issue. So they don't want to start it up. And that's your council right there. And your GNSO council, which is the entity that's supposed to be able to deal with this and create a working group and all that, the PDP, they don't care enough. So fantastic that Zach and Brian Zach from the ICA and Brian from WIPO are working on it. Fantastic they're having a webinar about the report. Fantastic that they're producing a report. But shame on the GNSO, where policy is developed, where changes have to come from, for not even acknowledging the work that's going on. Now, I was on the council as a non-voting liaison to the governments up until the end of last year. And I kept trying to get the council to pay attention, but they're not. And so you're just going to keep seeing this issue deferred until someone convinces them that this is something that actually matters. That reviewing a policy that now is how old? 25 years?
Yep.
I can't even count. Let's see.
I started it.
More than 25 years, yeah. To not do a review in a quarter of a century, think about that. It's ridiculous. So a lot of people are talking about it, except for the people that have any ability to do anything about it. And until they get convinced that this is something that should be done, it's just going to be chatter. Good chatter, but academic. And I'm sure I'm registered for the session on next or 2 weeks or whatever. Yeah, 2 weeks. And if they allow questions, or comments, I'll certainly make that one. And I know Zach's on here, so maybe he's going to be like, okay, now we're not going to open it up. But no, I think Zach, I would hope, not to put him on the spot, I would hope that once this report is final, that it does create okay, now we should use that as a scope for a policy process. And, I'm hoping that the group that can do something about it actually does. And I just see Paige up here, so Paige is also a frequent ICANNer, so I'm curious to hear what he has to say. Paige? Okay.
Sorry,
Yep.
I had to unlock the phone there. Yeah, Jeff, as always, thank you for giving a rip in an organization and a structure that's designed to exclude reality, common sense, internet users. You know what I mean? The non-participants that can make up the real world. And I just always, appreciate your comments because that's what I hear. I remember when I applied for a new TLD 23 years ago, we were pretty much told you have to do WIPO, but you don't have to, but you have to. You know what I mean? It's like, well, you chose to. Oh yeah, you have to. But
Yeah.
when I get scared or when I think how stupid or this doesn't make sense, on the whole, even the great work that Zach will do and everybody will do, are there super big extremes and pain that's happening? Or from like a weighted average ranking, say we did a beautiful ICANN study on the weighted average ranking of the negative repercussions of the current WIPO system. Are they mostly minor league, or what do you think is the one big thing that hurts people, registrants, that needs to be fixed?
Yeah, I don't think there's a huge thing that hurts registrants, and that may be the impetus for why the non-commercials don't take it up as a bigger issue. So I think that there's a lot of, you said, common sense things that if people actually read the ICA WIPO paper and actually pay attention to what they're recommending, I think it's common sense, but it's not broken.
Okay.
Oh, yeah,
Do you
Paige, go
like
ahead.
to eat the apples that your teacher gives you?
Yeah, Paige, you got to mute yourself. It sounds like you're
He's
being a
got
crossing guard right now. Well, let me say that Paige, if you're listening, and Jeff, there is something big, I think, that registrants.
Hold on. Is there a way we can? Let's see. Hold on.
Probably. I mean,
I got it. I muted his mic. Okay.
Yeah. Um, he's a crossing guard. Yeah, give this apple to your teacher, you little. Hey, so there is something big that I think registrants would like to see, and that is about the notification. Yeah, because a lot of people get these notifications. They would like to get it from their registrar. So one, it doesn't go to spam. I know David loves this. It doesn't go to spam. You're not confused about some bullshit from WIPO. You don't know the forum. You don't know, and plus it's a little intimidating, and you don't know should you answer. That's why notification needs to be assured, confirmed that yes, this person was notified. Which I know they're going to say we have some safeguards already in place, but to focus on the notification is one thing. And if a lot of people, I'm expecting Paige, of course you're going to be there, I'm going to be there. If there's 100, 200 people, 300 people that show up to this webinar, it's May 28th. All you have to do is go to dnlshow.com/outline, and you're going to just go to DNL Show, and click, and you can sign up for free. If there's a bunch of us there, then there will be somebody from ICANN there. Believe me. If not, somebody's going to let them know, here's how many people showed up. When there's 20 people that show up, 40 people, when they know there's 85 people showed up, why are so many? 120 people. So if we can show
Well,
that, yeah.
let me just correct one thing. It's not ICANN, the organization, that determines whether a policy process happens. It's people in the community. It's the IP representatives of the council, which are Damon Ashcroft and Susan Payne. It's the registry representatives on the council. It's I can name them all. Registrar reps, the non-commercials. Those are the people that set the agenda for the policy process, not ICANN staff. So when I say ICANN, I'm not in this discussion. I'm not referring to ICANN staff. They just essentially they support the policy process, and they will. If the council wants to do a policy process on it, then it'll get done. So that's not the people we need to convince. Um, but that being said, um, certainly, I mean, I'm not going to see the attendance list. Zach will. Maybe he'll let me look at it to identify members of the council that were on it, or he can identify it. But those are the people, not the staff, not ICANN staff.
Okay, and in your intellectual property constituency, and of course the ICANN BC, I'm a member of. We want as many people there as possible. Paige, go ahead. I know you had another comment.
Yeah, sorry about that. Yes, I am picking up my grandson Jax. He's with us now, so the next generation of domainers is with us. But I couldn't tell if you had a question or I just left my mic on.
You just left your mic on, except are you going to give him like $5? You give Julie $100 to turn into $1 million. You're like, hey Jax, here's a dub, $20. Go make me $1 million. Grandpa wants you back by. No, I like that you're there. You're handling business and you're taking care of the family. Paige, it's fun. Thanks for being
Well,
here.
certainly I can't help but think too back to the days when Jax was born 4 years ago. Was right in the middle of the clubhouse days, where this show started, and great to see everybody here. Everybody else. Those were exciting times. During COVID, I wasn't able to be there with his mom, but I was able to share with everybody that night that I was a grandpa. So anyway, it's always fun to think of Jax and then connect him to Clubhouse and connect him to everybody.
Okay, on behalf of Jax, too, let me tell you, don't wear tank tops when you pick him up. I remember I had an uncle that did that to his grandchild, and he goes, Grandpa, don't wear tank tops. Okay, so.
Well, it's funny. I'll finish with this since you mentioned tank tops. I had a friend of mine, he drove by where they're going to put the In-N-Out burger here in Murfreesboro in Tennessee, and I joked because everyone that knew me when I lived in California, I was always driving around visiting people, and if I ever ran out of clothes, I was always just $6 away from an In-N-Out Burger T-shirt. You know what I mean? The best shirt ever. So we joked that the ones here in Tennessee are going to come with the sleeves already, ripped out and cut out all the way down to the waist and stuff like that, Tennessee style. So there's my In-N-Out Burger humor.
Thanks, Paige. Finishing up on this webinar, yeah, sign up for it. Should be, it's interesting for domain investors. You're a registrant, okay? So then you realize, yeah, I don't like, I remember speaking with Ari Goldberger at NamesCon last year. Sure, wasn't that last year? Anyway, he said, yeah, like a lot of people say, be careful what you ask for. And, I do agree with that sometimes, except in this case, most of the time I don't agree with that. Be careful what you ask for. You got to move this thing forward. You can't be afraid, oh shit, now we gave the IP lawyers, all the brand attorneys more, I don't know, something else that we didn't want to give them. We, as domain owners, there needs to be some things recognized in the UDRP, and it's like from simple things like um, acronyms. I mean, there's got to be some things where you're thinking, look, this is, or the training of the panelists to know this absolutely is not a UDRP case, so don't somehow decide on it and decide it is a UDRP case. So there's definitely some improvements, and I just don't think you can worry about making it worse for yourself when you're trying to improve it. But, I remember, like I said, Ari saying that, be careful. And they say it a lot. I know, I'm on Team Nat Cohen, who's like, no, we'll worry about that. We're going to try to, get something reformed here that's better for the domain name owner, and we'll take our chances. But anyway, so everybody show up on, it's fun on a, when they see a big crowd, it should be all you guys. Okay, so everybody see on May 28th. It's 8:15 Pacific, 11:15 Eastern. Well, I'll remind you before then. All right, we got a bunch of stuff to do. I don't know what we're doing. The very first case today is armal.com. Okay, armal.com, I guess. I don't know how you pronounce it. If I heard that name, I'm a domain investor, been doing it for 25 years. If I heard that name, I'd think, well, first of all, no, I don't know any company's name that. I could care less, but it seems ARMAL, 5 letters. I'd buy it, not, I mean, I don't know how much, it depends on how much it's going for, but yeah, I'm interested in having that in my portfolio. Uh, in this particular case, there's this company, Sebac Servizo, out of Italy. Anyway, they filed this complaint against Beats out of South Korea. I don't know what the, okay, but the complainant rents portable toilets since 1987. Okay, so basically they're a big, they're a, the toilets are made by their sub company Armal, ARMAL. That's what they have this trademark for. But the complainant, and I think I had this right, was the official supplier throughout Italy. But this company is an international company. But still, I've been to events. I see these portalets and porta potties and whatever. I never noticed, are they manufactured by ARMAL? I'm certain there's several different manufacturers, but no, so it doesn't ring a bell with me. The disputed domain name in this case, armal.com, was registered in the end of December 2014. Okay, it resolves to a pay-per-click page with links related to the complainant stuff. So yeah, you go to the page and it has links like, hey, you need to use the number 1 or number 2. Anyway, click here. And it also has a link that says this domain may be for sale, minimum offer $900. So the standard stuff. It's got a PPC page, and then if you want to make an offer on it, you certainly can. The respondent said, the complainant made several unsuccessful attempts to buy the name, which is important when you're a domain owner. You're like, this respondent did answer and said, hey, they've tried to buy it. We didn't want to sell it. The respondent claims to be a pro domain investor, and we anyway. There's been a lot of cases where domain investing is considered a legitimate business, but the panel in this case, well, I got a lot of comments about the panel. I just gave you the facts. Let me throw it to who wants to jump in first. So you guys talk about a few more facts and then hit the decision. Here, Dave.
Yeah.
Thanks.
So I noticed on today's ICA bulletin, they talked about this case. And one thing that was mentioned is that complaint, you have to say whether or not, like have evidence in the response to say whether or not the complaint is the exclusive or predominant user of the mark. And I did a search on the WIPO brand database, and there were 60 trademark registrations on the database Some were expired, some were live, but from all different kinds of entities from all around the world. Then I went to opencorporates.com and I entered ARMAL and I got 92 companies that showed up. And then I clicked on active and 39 are active. So definitely they're not the complaint is not the predominant or only user in the world. And so I think if the respondent had that evidence, things would have gone better for him. But there was another part to that, and Jeff, maybe you can speak to that part.
Well, I'm not sure what specific you had in mind. I mean, I was going to speak to the whole Telstra kind of argument of it's implausible that respondent was unaware of the complainant's rights. Is that what you were going to refer to, David, or do you have something else in mind?
No. Let me pull it up. Hold on. So
Yeah.
Zach wrote.
Oh, I didn't. Sorry, I
Parties,
didn't read there. I haven't read that yet. So yeah. Okay, go ahead.
yeah, there are genuine reasons for registering the particular domain name apart from the complainant, such as a term having a common meaning, or that is an apt name for a party to adopt for its business. Well, given that it's a surname, not very common, but still surname and a forename, and it's used by, or has been used by 92 businesses, and 39 are active, and there's 60 trademarks, I would think that'd be a good name to register. What do you think, Todd? Is that a good reason? Like when there's like 30 plus companies that would want it, isn't that
Well, David, I'm
something
glad you
some
brought
kind
up
of name
Zach's
you'd go
comment
after?
because sorry to cut you off there, because what I was saying was, yeah, I'm not familiar with that trademark, but that still doesn't mean if you are familiar with it, you're familiar with the trademark. And Zach brought up the example of Acme. Say someone has a trademark for whatever slots, and it's in one category. That doesn't mean you have to stray away like, oh shit, I already know somebody has Purple. It's a fucking mattress company. Well, you can still use purple as something else. So just because you're not aware of it doesn't mean you can't register a domain name. It's not going to prohibit you. And if you answer back, um, you know, depending on what your answer is, um, it doesn't mean at all that you're targeting. So that was the important thing that I think Zach brought up was, yeah, many times you'll just immediately, think, I didn't know of them. I didn't hear of them. You don't have to worry about it. If you weren't targeting them and you're using it in a different category, or you really even haven't used it yet, that's how I always felt as a domain investor. I haven't done anything. Whatever I do is going to be within the laws of your little world here, you domain dispute world, whatever. I'm not going to infringe on this complainant or that complainant or anybody else. I'm allowed, domains are first come, first serve. That's how they've usually always been. And that's why before you even do anything with the name, even if it's got somebody's mark in it, as long as you don't put PPC pages up and are trying to confuse people like a lot of parking companies do, you really do have rights to names, even though it could be really limited and maybe you need to keep it non-commercial. But I've always felt like, listen, I got this name. I know there's some ways I can use it without infringing, without causing a problem to some mark holder. So I have a right to it. And like I said, some names are real limited. But anyway, so ARMAL definitely
Yeah.
is a
Well,
domain
my
investor.
point on this thing, like that I really didn't like. Yeah. So they do say there's some pay-per-click ads on this that point to complainant. I haven't looked at it or anything. But what I didn't like was the paragraph that it says, given the complainant's international presence, although it was not in, well, let me read this because it's interesting. Given the complainant's international presence and trademark registrations for RMAL worldwide, it is implausible that the respondent was unaware of the complainant's rights in the disputed name at the time of registering the disputed domain name in 2014, so it's 11 years ago. While it's noted that the complainant's trademark application in Korea was filed after the respondent's registration of the disputed domain name and is still pending, the panel considers the overall context of the registration and use of the disputed domain name by respondent. Um, And so to me, that is saying there's a complete lack of demonstration of awareness, right? Like it was not in the respondent's country. So to just automatically say, well, it was in world use, even though not in your country, you were aware of it. Like you had to be aware of it. It's implausible that you were unaware of it. Look, it's used a shit ton in our country, I'm sure, but I'm not aware of it. I don't know anything about it. Um,
Did
but
you say
you know,
did you say shit ton
I
in this
did.
case? Oh, that's fun. Well, I know we didn't even mention, Jeff, that this was a transfer. So the person lost the name, and I got some comments, but I see Paige had his hand up, and I always love to hear from a lay person. We're not lawyers, right, Paige? But Paige, what comment did you have about this?
Well, one, I think your comment about if someone's got a trademark and it's not in a class and you're not going to do anything bad, that's always on your side of it. I think there's a spectrum. And, if you have, if you do really have knowledge of a famous word, then I would be careful, and I would be interested what Jeff and you would say about, even though we know parking is probably taboo, even though not in every case, whether a for sale page is enough to have you lose the third leg. And then secondly, I was shocked, Jeff. I thought you were reading when you talked about it's implausible that they would have known. Were you reading from the complaint or were you reading from the decision? Because you're right to conclude that in the decision without a lead up or any evidence whatsoever and then transfer. Were you reading from the decision or the complaint?
Decision.
Wow. And is the complaint ever public? I was actually got my first WIPO, although it wasn't me. It was an account that I help administer. And she asked me, the woman who was the true owner asked me if the complaint and the response are public. Is just the decision public or is your response public?
Just the decision.
Wow, then I agree with you. Yeah, to say something's implausible without the following reasons why it's implausible, uh, that's the risk of WIPO, right? You can be right and they can say you're not, and that sucks. And that's what I tell all beginning domain investors. You can be right and single arbitrator or a panel can decide you're not. And that's just the name of the game, I guess.
Yeah, go ahead, Brad. Before I get to
Yeah,
some
I just
comments about
wanted
the
to.
panel, go ahead.
I was thinking the exact same thing, Paige, that what Jeff was reading was the attorneys that were representing the company's complaint filing verbatim. That's exactly what an attorney who is representing that domain name would put in their complaint verbatim. I thought that was exactly the same thing.
Usually, you guys will see this
Well,
in.
they might have actually. The panelists sure might have copied that language, but the panelists shouldn't make that. Basically, they're saying that the mark now is in use in 130 countries, whatever that means. Uh, but at the time, in 2014, it was not being used in the Republic in South Korea, where the respondent is. But to make you have to not only say that it's implausible today if you registered the name that they wouldn't have heard of it, but it's implausible at the time it was actually registered, and that's what the decision says, and that kind of bothered me because of the admission that they weren't in South Korea at the time.
So, you guys, the panelist does provide a summary, okay? And they'll add his decision in there, but just a summary of the complaint. So we don't see the full complaint. We don't see the full response. Now, Paige, of course, if you're involved in it, you're going to see the complaint because they're going to send you a copy. Your client is going to see a copy of the complaint. Now, in this case, the panel did say the respondent did not rebut the complainant's case. And the respondent did answer in this case. So it wasn't one of those where he didn't answer to even try to explain his side of the case. The panelists said they didn't rebut what the complainant had said, hadn't shown any legitimate use because this PPC page, according to the panelist, shows no intent to use the disputed domain in a bona fide way, which that is parking as a whole business. And parking revenue, whether you're getting 1 penny a year or dollars a day, it is a business. Now you got to need to be careful with the PPC, but for them to say it shows no intent to use the disputed domain in a bona fide way already would upset you as a domain investor. But the panelists said, like Jeff mentioned, implausible that the respondent has not heard of the complainant. And like Zach mentioned in his comment, and you do need to check out the UDR, the blog posts at ICA. They're pretty fantastic and some great comments. And by the way, Zach did mention Jeff and Paige that in the back channel to me that the comments section is open for this webinar. So you can go there, sign up now, make your comment. And of course, he did say he's going to block you, Jeff. No, he said
I figured, yeah.
The comments section is open, so people can make comments. That way, it gives them a chance to know. All right, so we want to address these things because they're going to try to be organized. Because if you're not, then it's a big mess. But okay, so in this RMAL case, Andrew Park was the panelist, and he said yes, they got a trademark. Yes, this person has no legitimate use, and yes, they registered it in bad faith. And how he came to the bad faith, he said, for passively using this domain for a decade in the PPC lander, that equals bad faith by not really doing anything with it. So yeah, definitely disagree with this decision. Anybody, David or you, the guests, anybody have any more comments before we move to the next case? That's a transfer. ARMAL.com was transferred away from the domain owner.
Yeah, I was just trying to check out this panelist, Andrew Park. He started off domainer friendly, and now it seems to have gone off the rails. So I don't know if there's some sort of quota he has to meet. But I've noticed a lot of Korean panelists lately deciding against their own countrymen. The domain was registered in Korea through a Korean registrar, and the registrant is Korean, and the proceedings were done in English. Like, why? How does that happen? So,
well, it would happen if what registrar do they use?
It's a Korean one, Mega Corp or something.
Yeah, but they may have the registration agreement in English. Do they even? I didn't look. I sometimes skip the procedural stuff. I didn't look, as they're supposed to address that.
It sounds like the panelist was lazy and just took the wording.
Yeah, I mean, it could very well be. We just, but there are panelists that still don't view the buying and selling of domain names as a legitimate bona fide use. The good thing is that there are more panelists that do recognize that it's a legitimate use, but not everyone. And that's, this is one panelist that does not believe that the buying and selling of domains amounts to just passive use that is not bona fide, which is wrong.
Yeah, Brad, what I read into what you just said was that it seems to be that they're deciding first and then they're writing an opinion to back up what they decided. But whether it's gut feel or bias or whatever, but I would say, and Jeff, you probably, this is not legal advice and no one's getting legal advice on the show, but you have to almost assume that the panelists could go any which way in your response, whether you do it with counsel, whether you do it with esteemed counsel, experienced counsel, even yourself. Say it's a name that you just don't think is worth, defending, but you want to just do it yourself. You would have to just assume that the panelists could go in that direction and try to cover everything. Almost even if the complaint didn't assert it, you know what I mean? You almost just have to try to cover everything because you don't know where that panelist may go in his opinion. So you almost have to preempt it, I would say.
Well, I would say I do that in court too, right? Whether it's court or UDRP, you always assume that it's your job to convince, even if it's not your burden technically, like it's not a respondent's burden to prove that they're operating in good faith. It's the complainant's burden to prove bad faith. Um, you always assume that you're going to lose, and it's your job to convince them why you should not lose. Um, and so, yeah, I mean, that's pretty much a given. But you're right. Under the UDRP, more than 95% of the cases are, and rightfully so, our complainant wins.
Another thing that
I'm sorry to interrupt, but 95% really?
But yeah,
Wow.
well,
Wow.
but before you say wow,
Right.
majority of those cases, the respondent just defaults, doesn't even respond.
Okay.
And if you look
Okay.
at it, you'll see that if you looked at the list of cases that were filed every day, you'd be like, yeah, okay, like it's famous mark / descriptive
Gotcha.
term,
Okay, gotcha.
right?
Gotcha. So it's not like every time we see it, an ICA note or you guys cover one, you guys are leaving out the 25 easy to decide, famous name, no response cases. Okay, I see what you're saying.
Yep.
another thing that I think would be important when earlier discussion about recommending some changes, or besides having a better proof that the um, other party received actual notice, because there's no certified mail, or there's actually no way of actually knowing if the other person received the notice. But what David brought up in this case was the panelists should have a requirement to at least look at trademark sites or other sites before they decide to see if there actually were other usage in other trademarks.
Well, Brad, that's the whole thing is the panelists, there's no requirements. The buck stops with the panel. There's no overseeing the panelists. That's why when we talk about this overview that Zach and Brian are going to give, yeah, we want to know who can reel in the panelists. Well, there's no way to do it. I mean, basically, right now, the panelists they decide. There's the judge, jury, everything. The only thing you can do is when there's a bad decision, and they can make a terrible decision, then you can go to court. Well, who can go to court? 100 grand, 50 grand, 100 grand to file an ACPA. It depends on how involved it is, but so it detours nearly everybody. But that is the biggest concern, I would say, as a domain investor, somebody who knows about the UDRP process, is these panelists. There's no oversight for them. They can decide, and now we talk about it quite a bit, where they start deciding on cases that you think this is a trademark infringement case, so this needs to be in court. Why are you even deciding it here? But there, like I said, no oversight for the panelists, and that is definitely in Brad, you were bringing up more of their education. What is their responsibilities or requirements or obligations for research? They don't have any. Some do some research on the disputed domain name. Some don't. Some will check archive.org only because a complainant has made some claims about it in the past, and they'll check to follow. But anyway, so the
No, but I even heard in previous these that they don't even look up to see if the domain is active or being used or whatever, right? I mean, there should be at least two things on the checklist that a panelist, you know, before they make a decision, at least check, go to the website. Number two, go to a trademark site and just do a cursory review as opposed to nothing. That's not, substantial just to have it all in a person who's an attorney, who's a panelist. He doesn't even have to go to look to see if he has to even question what the attorneys that are giving him the information, if it's correct or not.
well, for uh, since Brian Beckham's going to be with Zach on that webinar, that's something. Brad, go into the comments and say what research requirements are, must the
Well,
panelists adhere to, or something like that, and see if there's,
yeah, but
yeah, go ahead.
but the way I'd answer that is there's two different philosophies. if someone goes to court, a judge only looks at what's put in front of them. They're not allowed to research. They're not allowed to look into things as if they are an advocate for one side or the other. It's decided based on what is in front of them. And so if there's a case that's filed, yeah, to verify that the trademark that's submitted by the complainant is actually granted and is actually represents, that's one thing. But to go and to look at other trademark sites or to see what else is out there in the world, that puts the judge, in this case a panelist, in the position of advocating on behalf of the respondent. That's the respondent's job. The
So
respondent.
Jeff,
So hold on. So
yeah,
I agree with you you, Brad, that I as a panelist would absolutely go to the website to see what's going on, to verify that what the complainant is saying is true. I do that. Not all panelists do that. And I do go to the site that has the trademark registration, to check for myself. Yeah, this is a real trademark registration and it's a good standing. I look at things like disclaimers and stuff like that. But I would not, as a panelist, do a Google search necessarily. I would not necessarily go in and check the WIPO database to see how many others are out there. That's really the job of the respondent if they want that introduced into evidence. Um, and I do more research than most. I like to look at archive.org as well, especially when there are things in question. So I
Well,
agree that
how
the
about when the
complainant,
respond
the
when the
complainant,
respondent's not even available, right? In most of these cases.
well, one doesn't know why they're not available. Is it because they choose not to be? Or is it because they didn't get notice? We never know. And in fact, even though Todd said earlier on, one of the things he'd like to really see as changed is, notification by the registrar. We don't know for a fact that the reason why respondents aren't responding is because they don't have notice of it. We're making that assumption um, based on, circumstantial evidence. But the reason it's not as big of an issue is because there's no evidence that that is the reason why respondents aren't responding.
Right. No, I can.
That's a great point. That's a great point, Jeff, because like Moniker, and I hate to say it, I still use Moniker for some things. They send out those annual notices. Make sure your who is information is correct. And sometimes a WIPO notice could even look like that. You know what I mean? Or just look like a blah, blah, blah. And like you say, there's no one following up and going, oh, hey, we better call this customer and make sure they got it or something like that. I mean, it's just supposed to all run itself. But back to this, you mentioned the reply. If I was replying in a WIPO case, even though my response isn't going to be published, I have to assume that the panelist, if they wanted to, could quote any argument that I had made. Would that be
Yes,
accurate? And
that's
that could
accurate.
make it into it. So if I wanted to say something like, "Hey, listen, I didn't want to tell you this, but what I really wanted to tell you was, something like that you think is like between you and WIPO, I mean, it's not you. I would have to be ready that he could reference anything in my response in his decision.
Yeah, absolutely. You have to assume that, and in fact, when respondents win or lose, they're quoted, right? So, absolutely. Yeah. Anything you submit while the whole response is not public, it'll be included in a summary by the panelist and or they could directly quote what you said. Absolutely.
David, you had a comment. I got some things to
yeah.
say.
So there's two things. So um, as a panelist, it's a unique type of forum where it's not a real core. People don't really recognize it. They have no clue about it generally. When they sign up for a domain name, it's not brought to their attention. There is a maybe 30-page document that they agree to some terms and conditions, but I can assure you that 99.99% of people never have read that. In fact, I don't think I have even read it from beginning to end. I maybe glanced at it a few times, and it's been changing over the years, but I haven't seen updated copies. And to that point, there are most lawyers who would respond to a UDRP complaint as a respondent for the first time would never cite the necessary cases for certain principles that they have a legitimate interest in a domain name or there's no bad faith based upon certain factors. They don't know what cases to cite. They don't know that, oh, it's okay to have PPC on a page, and this case says that. People don't know. And I think since this is a global forum, a dispute forum, it should be more like the French method where they have an inquisitor who actually digs deep and finds out what are the facts. Am I being snowed here? Are these people trying to pull one over on me? Because there is no bar or ethics that people have to abide. You can file them from anywhere in the world, and there are no repercussions. Look at the guy who filed a complaint for KS.com. He's a fraudster, but he thought he could steal a great domain name through a UDRP complaint. And people play games. And
Oh yeah, well, people always play games. I mean, I'm not going to dispute that. But when I know in the forum, and I believe WIPO, when they send the copy out of the complaint to the registrant, and let's assume the registrant receives it. Certainly, if they hire a lawyer, they've received it. It does say on the cover page, usually it's got a citation to resources they could use. They also, in WIPO's case, I believe, cite to the WIPO overview. Now, that doesn't have every subject in it, and may not have the stuff in the, um, there's additional stuff in UDRP perspectives that Zach and others have worked on. But look, if a lawyer doesn't know where to go, then that's not the lawyer that should be handling it, right? Lawyers know how to do legal research, and it doesn't take very long. Usually complaints cite the WIPO overview, right? So respondents, if you represent a respondent and you're reading the complaint and they've cited the WIPO overview, then your first duty is, as a lawyer, let me go look at that overview thing. Oh, let me see what subjects it touches on, right? So lawyers should know how to do legal research and to find it. I don't buy the fact that lawyers that respond for the first time, if they don't do their job, that's on the lawyer. But I do agree that there should be a much better precedential legal library of cases. And of course, Jerry uh, has tried to do that with his treatise, which is really good, Jerry Levine. And there's that out there, and there's sites out there. Um, but yeah, there's no excuse for an attorney not to be able to research and find cases, in my view.
Welcome, Eric. Did
Just
you have a comment?
another thing that you said, Jeff, and it's I can totally, it's true. In a court case, the judge shouldn't be an advocate, right? But this isn't court. This is kind of like almost like court or something. And if you're a panelist in a UDRP case, then you should at least have a different set of criteria, knowing that it isn't court, it's less expensive, and it's possibly a pre-court case. And one of those requirements for a panelist should have a little more due diligence. Just, even if it's cursory or superficial, but, or have an assistant look at the case before it's given to the panelist and have them do, just some search or the slightest bit to make it fairer for the domain owner that isn't represented. and they might have, then they have legitimate rights to it. And for sure, 90%, or if someone doesn't come in to defend it, then they probably were cyber squatting or weren't comfortable enough. But there's a lot of things that we go over in this where they shouldn't have lost their domain, and they did because of lack of, commitment on the panelist, or the lack of requirements.
Well, Brad, what you're saying about the panelists being knowledgeable, I agree. They at least need to be knowledgeable, and they can still be fair without tipping their, putting their hand on the scale one way or the other. Arif, welcome. Did you have a comment or question?
Yeah, it's pretty much what these guys are saying. They said it for me before I could say it. But yeah, I just think it's, the fact that it's not really a court case, and resources are also not necessarily symmetrical in these cases, right? And the fact that, if somebody is, has a URP against them, there's no punishment, if case of RDNH, which would mean, okay, yeah, at least they could get a lawyer like that. So any expense, right, to defend yourself, even if you're completely innocent, it's completely at the expense of the defender, right? So in that, and plus also we can't forget that, WIPO and the other ones are kind of contracted out by ICANN, right, because of their technical skills. So, those technical skills, you don't want to necessarily ignore them either. If they have a database of trademarks at their disposal by those companies, well, that's not unreasonable to expect them to do a minimal amount of research. But yeah, ultimately, I think it's, again, it's, there's no recourse for the defender to be compensated for the legal fees. So, and also, again, but as already mentioned by the other guys, I just want to reiterate it, is that, people who have domain names, they don't necessarily know the laws and whatever it is, right? There's no course that people need to take before buying a domain name. And that's like, sure, you need to know the laws a little bit, but these are really fine points, in terms of trademark law. And it shouldn't be expected that every citizen of the world knows the full depth of trademark laws and how they apply to domains and all that kind of stuff. Yeah, sure, it's in the fine print, but the reality is that it's not quite the case. So, all these things, I think there should be some minimal work if in certain cases, right? And I agree, like
All
95%
right, let me ask.
probably independent.
Let
Yeah.
me ask this question, right? Because it cuts both ways. Let's say I get a case as a panelist. Should I research if this respondent has lost other cases if the complainant doesn't bring it up? Should I just go and say,
If it's
I
if it
wonder, I wonder if, and then I find out, wow, this respondent actually has been the subject of 75 UDRPs and has lost 73 of them. So they must be guilty in this one. They must be.
well, no. Well, I mean, I don't mind them doing looking that up, but that just, it's one part of the evaluation, right? Like, look at the 73 cases. Like, how are they applied? Was a person already informed of that stuff? That doesn't bother me at all, right? I mean, there's a lot of people who buy domains, who own domains, who abuse the system, who I have no qualms with them getting their domains lost, right? Somebody registers Coca-Cola-promotions.com and gets it taken back from them by Coca-Cola. That doesn't bother me at all, right? There's various degrees, and there is judgment, and there's gray zones, right? And that's why these rooms are really good to figure out, to get out the gray and go more black and white, but there's still always a gray zone. However,
So if I find
there's
out,
still a lot of information.
if I find through, let's say, a complainant didn't bring up everything that they could bring up against the respondent that they could use, and then I, through my research as a panelist, find, oh, you know what? The complainant didn't mention this, but I found this, and this to convince me that it's being used in bad faith. That's okay?
Again, it would depend on the information and where it's available and how reliable it is. But again, it's if the person has 73 cases against them already in WIPO, and those cases apply, like, are pertinent to the current quick case, again, that wouldn't necessarily bother me. But again, like, I'm trusting you to use your judgment on if it applies. I'm really sorry, guys. My mom's calling me. It's gotta go. But yeah,
Sorry.
great conversation.
Yeah.
Yeah. So, Jeff, on that point about losing prior cases, for example, in that guy Jeff Burger who lost a few cases and didn't lose GWG. Well, I think every case should stand on its own, and even if the person lost 73 cases previously, that unless it's somehow related, the marks are similar, there should be no, um, it's the same WIPO and not a form. I think there should be no regard to that because that's called implicit bias. And bias is something that judges are supposed to be aware of and not engage in bias. So any panelist who looks up, oh yeah, this is that guy who has 10 million names or 2 million names and he's lost 50 UDRPs or 100 UDRPs, that is not relevant.
Well, I mean, there's lots of things. There's lots of examples where research could be, and we saw some cases where they did and I can't remember how long ago it was, but probably about 6 months ago on this show, we looked at a case where a panelist did a whole bunch of research and then found against the respondent based on the research they did, even though the complainant didn't make that argument. It's been a couple times. And so my only point is research done by the panelist uh, could be used either way. And if we're okay with that, that's fine. But you can't say that it can be used against a complainant, but it can't be used against a respondent. And I think in a lot more cases, if analysts did the research, they might find more out there that the complainant never said or pointed to that would justify whatever way they wanted to go. And so that's my only point.
Okay, everybody made a lot of
Well,
great points.
that's a very good point, Jeff, and it makes a lot of sense. How about something
Hold on, we
like
got Brad.
you don't have to?
We're not going to stick around here 2 hours today. Are you kidding me? And when did
Okay, I'm on.
everybody? And you guys can make. You know how it is here. I mean, Brad knows. Paige knows too. We can come up and make comments. Except you guys are hijacking the whole thing. I mean, we don't. We're going to go into one case for fucking an hour. Excuse my language. But anyway, so Jeff, yeah,
Good discussion, though.
what we're hoping is when the panelists do the research, and I'm certainly not going to go on, is that they weigh it against the evidence. So sometimes a complainant may say, "Hey, this domain name has pay-per-click links to our competitors," and then the um, when the panelist looks at the pay-per-click page, okay, and they see not only is it going to a competitor, it's showing the actual complainant. So we're, hoping that the panelist says, geez, just doesn't, totally tilt the scale in favor of the complainant saying, hey, you didn't even know this, but there's actually links to your company, when the complainant didn't bring it up. So they're certainly going to find things when they do any research, and then you expect them to be now more knowledgeable, but they still need to be fair. Okay, I see a page took off, but I wanted to mention that about those 95% of the cases that you say, we know those are like Walmart callcenter.com, and we know, so that's why 95% of the cases we don't deal with. And here we deal with the 5% that could go either way. And of those 5%, about 60% of those do end up being transfers. Um, there's still about 98% of all cases seem to be transfers, and then of those 98%, 3% I'd say are questionable, and then 2% are complaint denied. And that's why sometimes when we read these complaint denied cases where John Berry Hill's successful and so on, I mean, and including you and Zach when we're defending the respondents, those are very minority, they're in the minority of cases. Okay, um, yeah. Anyway, Tomo.com. Sorry, Brad. I know Brad doesn't care. Brad's like, Todd, I understand. You got this show to do. Tomo.com. We're only on case 2. Oh my God. Okay, so this is a pretty big name. Tomo.com, registered in 1996. Tomo Credit is the complainant in this case. Audrey Trout of Tomo Networks they're both the U.S. complainant and respondent, is the respondent in this case, Audrey Trout of Tomo Networks. So the complainant has a trademark for their credit services since 2019. They're on the domain tomocredit.com. They also, yeah, that's it. They were on a Tomo Credit. I think, are they on Hello Tomo too? Yeah, they were also on Hello Tomo. And just saying that too, I always think if you can't get a great name and, you know, anyway, like Hello, you got Hello Tomo instead of Tomo by itself. Well, you know, I don't think it's always necessary for somebody to upgrade, because, sometimes you just can't upgrade and people are going to know, hey, I'm looking for a credit services, not this, ice cream sundae website. So anyway, but in this case, the, um, the respondent was using Tomo Network and Hello Tomo. Well, they eventually bought Tomo.com. Okay, so that's how they ended up with Tomo.com. They were first on these other websites. And when they picked up Tomo.com, the complainant, I have all sorts of dates here that really mean something about when the respondent applied for their trademark in 2020 and then for their Tomo network, and then it eventually got registered a couple of years later, about a year and a half later in 2022. Well, the complainant sent a C&D letter to this respondent. This was after the respondent had their trademark. This was in August of 2022. The respondent, the domain owner, just didn't even answer. Sent a C&D letter and said, "Hey, we don't want you using Tomo." And the respondent was like, "We legitimately use this." Didn't even respond to it. So this is the case where the complainant then petitioned in July 2023 the USPTO to cancel their trademark and said, "Hey, we want you to cancel this trademark you granted last year because we use the term Tomo for credit services, and we don't like this Tomo network. We think it's too close to what we do." For some reason, anyway, the trademark owner, the respondent in this case, the second trademark, did not reply or respond to this petition. So the trademark was canceled. So terrible news, the trademark was canceled. And then, after the trademark was canceled, then this complainant files this dispute and thinks they have a chance at it. Well, so David, since I wanted to ask you earlier, what's involved in filing a petition to cancel a trademark, and what percentage do you think succeed? I know it can't be a majority, but tell us a little bit about filing to cancel a trademark.
Well, there's different ways of doing it. So under the trademark, there was a new Trademark Modernization Act that happened in 2021 or 2022, and that added 3 more ways you can cancel a trademark. In this case, they filed through the regular TTAB process saying that the mark is recently registered, but it's confusingly similar to our mark for the bogus reasons they wrote in their complaint. And that was filed, and there was dates given for a response, and no response was given. So it was a default automatically, like the registrant loses in that case. Another way is if a mark is older than 3 years old, you can petition to say this mark is no longer in use for the goods and services registered. And you supply some evidence. This is, you pay a fee, it's a smaller fee, it's not adversarial, and you submit it, and they look at it and say, okay, this looks complete. Then they send it to the registrant. And in that case, if they don't respond in 90 days, which is a long time in trademark worlds, 90 days, that's good. They don't respond and they lose their trademark. They can recover, they can, say, okay, I missed the deadline and pay a fee and get back on it. But it's not like it's dead forever. There's a couple other ways, like, oh, the specimen that they submitted for the registration last year was fraudulent. Here's the evidence. They never actually used it. It was, some made up evidence. And here's how I figured that out. So that's something new that you can do. And there's one other way I can't remember right now, but that's generally how it's done.
Well, Jeff, before I ask you a question about this case, so what happened here? The trademark was canceled in October of 2023, but a month prior, in September of 2023 is when this respondent bought this disputed domain. They bought tomo.com, which we know it was, I think they bought it from a Korean or somewhere in Asia. The domain owner had it for, a couple decades, and it was probably a big price, but they bought it from, some third party in September 2023, and they forwarded their other domains, those two I told you about, Hello Tomo and Tomo Networks, that they've been using since Tomo Networks since 2020, Hello Tomo since 2021. That's important because the panelist said the evidence doesn't show that the respondent acquired the domain name to capitalize on the complainant's trademark. They, in fact, were using it for their own stuff. So this was a three-member panel, and they said the three-member panel did say, yes, this Tomo credit does have standing. They do have a Tomo, a trademark for Tomo, Tomo, but they didn't show that this other company, this other person, didn't have legitimate reason to have this name, and certainly didn't register it in bad faith. So they denied the complaint. Jeff, was there anything, in this case?
Well, in this case, the trademark cancellation is a red herring. It's not really relevant because, again, it was a default. And you also have to remember, trademark rights accrue by use, not because you have this piece of paper that says you have a registration. Yeah, there are certain remedies that you can only get by having that piece of paper. And yeah, if you apply for trademark cancellation because the trademark's been abandoned or there was fraud or something deceptive, genericized, all that kind of stuff, that could be relevant. But in the UDRP, the criteria for establishing a right or legitimate interest is that you were using the mark or that you had a bona fide use prior to receiving notice of the dispute. And that's it. It doesn't matter that the trademark was canceled. Were you using the mark prior to when you found out that there was this dispute? And the answer in this case is yes. They were using the mark prior to finding out about the complainant or this dispute, before the cease and desist letter, before the cancellation, all of that stuff. They had been using the mark, and that is the second element. Basically, the panel here said, you, the complainant, can't establish the second element. And we are convinced that the respondent was using the mark prior to when it found out about this dispute, and therefore UDRP is in favor, finding of the UDRP panel is in favor of the respondent. That doesn't mean there's not infringement. It doesn't mean that they may not go to court, the complainant, but for UDRP purposes, merely using the mark, a bona fide use of the mark prior to the dispute is enough um, to rebut the second element.
Yeah. So yeah, I'm saying yeah.
Yeah,
No, Jeff, that's
so
exactly what happened in this. Go ahead.
the facts here are that the complainant only got their first trademark registered in September 2023, which is around the same time the domain was acquired. But the respondent incorporated his Tomo networks in May 2020. And if you go to Google Trends, they weren't really that popular until 2021, 2022, actually. February is when they started getting some popular, some trends for Tomo credit card, but nowhere near necessary to like compete with any other brands. So it's a niche product. They offer a credit card that you can order through an app on the iPhone store, the Play Store. It has nothing to do with mortgages or real estate. So they really didn't have a bona fide case for confusion. And yeah, this case was dead on arrival. But the prior owner was a Japanese owner, and there are Japanese restaurants called Tomo. And
There are people I know named Tomo is a shorthand way for or nickname of one who's named Tomoko, which is a Japanese name. Um, so that argument wasn't used, but it's just interesting because I have a good friend named Tomo.
Yeah, that's what my friends call Todd's mom, Tomo. So no, I'm just kidding.
Well,
Okay,
but that's
yeah,
different reasons.
yeah.
Anyway,
No, interesting. So this was the Tomo, just like ARMAL. This is the domain name that domain owners would like to have in their portfolio. Okay, you own TOMO, you expect to really, I mean, if a domain investor to have a big sale with a name like this, CVCV, especially pronounceable, but fantastic. The domain owner, Audrey Trout, got to keep the name because Lawrence Nodine, Sally Abel, and Peter Dernbach were the three-member panels ruled, as we all think correctly. This next case is our final case for today, IIA.org. Okay, so it's a three-letter .org. The complainant in this case, the Illinois Agricultural Association versus James Brown. No, not that James Brown. This is like Brown with an E, like Jackson Brown. No, not that. So this was a California domain owner, owned this name. He was part of some alumni group, and he got the name because he was part of some alumni association. So he registered IAA for his alumni association. But this complainant came in there and said, hey, we're the Illinois Agricultural Association, which we know is already goofy. That's why when I looked at this case and I see IAA, someone filed a complaint against it, I'm already suspect of who's filing against this acronym. So anyway, was this Agricultural Association out of Illinois, been around since 1912. They said they had common law rights since 1912, and they had a USPTO trademark since 1989, but the trademark was actually for um, it was long. It was basically for IAA plus County Agricultural Association or Associates or something. So it wasn't just for IAA. So the complainant made their case or submitted this complaint, and it was really misleading. It's like, or it wasn't misleading enough to fool Alan Limbury, who friend of the show. He's out of Australia. He's down there. He said he plays golf on Wednesdays, which that's why it's Wednesday morning where he's at right now. So that's why he never comes into this room. But he was the sole panelist on there, and he said that that the respondent did not submit any evidence. I'm sorry, the complainant did not submit any evidence of the trademark. Basically said, or showed their trademark, their USPTO, but said, well, that shows IAA, County Agricultural Associates. That's not even just IAA, so that's misleading. And then your common law stuff since 1912, you didn't submit anything worthwhile there, so you claim to have this trademark for so long, and this guy's infringing. And then the complainant also brings up, by the way, we contacted the IMSA, who supposedly, that's this alumni association, or the school. They said they didn't own it. The alumni association said, we don't own it. It's an individual here. So thought that the complainant thought that would make a difference to say, hey, this registrant is misleading people. Well, Allen basically ruled and said, the first prong, you didn't even prove to me that you have a trademark on this thing, that it's confusingly similar, that this domain name is confusingly similar to the trademark that you do have. So Allen didn't even rule on the second or third prong, and also said, hey, you should have known that you weren't going to win this case, and ruled you abused the system. So the complaint denied plus an RDNH. I like to see it, but I didn't really think it was an RDNH case, even though I think they probably should have known that maybe they didn't win. But I mean, even though this is an acronym, and I don't like when someone goes after an acronym, I don't, I just didn't think they were doing it to well, maybe I'm wrong, to abuse the system. What do you think, Jeff?
You mean, what do I think about whether he abused the system?
Well, I look at it further. It's probably a Plan B case. It probably was, but yeah, what do you say about the RDNH?
I mean, so they're not for, like, you kind of look at the complainant. They're a not for profit. Um, I mean, yeah, I think it was doomed from the beginning, but um, uh, but yeah, I mean, it was. I do think it was RD&H, but I might have had a little bit more sympathy on this one.
Yeah, I think you're right. I think I was wrong. David, did you see this? So it really was a plan B. The guy tried to buy it for 500 to 3,000. He went through a NetSol broker, but there was no response. So then he went after the domain. So yeah, I think I was wrong. I think this was actually clear of RD&H. What do you think?
Well, I don't even know why he went through a NetSol broker because the name is that Namecheap. So maybe the domain owner was never even reached. But besides that, the trademark is longer than the domain name, and that's an important fact. And I think that was a deciding factor in this case. So that's why it was denied.
Yeah, and maybe he went through the NetSol broker because they have their name at NetSol, and they just reached out to their registrar and said, "Can you help
Yeah,
us?"
remember
Yeah.
NetSol claim. Well, NetSol also has Mark Monitor, so I don't know if they technically used Mark Monitor as the broker, because that's something broker or yeah, Mark Monitor does. Um, but they're owned by the same company. So yeah, if NetSol is their registrar, you know, they're trying to integrate it all into one anyway. So I think that probably is why they went through and says NetSol broker.
Well, everyone, thanks for being here. I appreciate Brad and Paige and Arif for making some comments and joining the conversation. We always like it. I try to keep this thing 90 minutes to 2 hours. We hit 2 hours. But I wanted to say Paige is doing a room now consistently every Monday night with his daughter, Julie. It's called Monday Night Domains. So you got to check that out. It's here on X. So that's Monday nights, 4 p.m. East or Pacific, 7 p.m. Eastern. Check that out. Of course, we're here every Tuesday, and we'll be here next week. We got some good cases already lined up. Noon Pacific every Tuesday. Been doing it for, I don't know, 4.5 years, 3 p.m. Eastern. So please join us on domain name law. Now, I'm going to say it again, and I'm going to send out some posts on X and some messages to folks this Thursday, 10 a.m. here on X, 10 a.m. Pacific, 1 p.m. Eastern. So your afternoon on the East Coast. Josh and I are going to welcome Sten Lillestrom. Sten's just going to drop in from Sweden. It's 7 o'clock at night, his time when we start the show. He's going to, he's the number one seller at Adam for years. Great portfolio. I'm going to share some links on our dnx.show outline. And we're going to talk about brandable domain names, obviously domain investing. Got a lot of topics, but just have Josh asking questions to Sten asking questions to Josh about their domain investing strategies. Hugely valuable if you're a domain investor. So you want to hear what do a couple guys do that do it full time that absolutely make a living off of it. So there's, other than Paige and who were the other? Stephen Kennedy, and of course there's a few others that do it full time. Most of the time they end up being brokers who, they do a few other things. They're not just domain owners. Mike Mann, Domain Market, but he does a few other things too. But I'm saying these are pure domain investors that do it full time, that are at the top of the game. These are the messies, okay? And they're messy sometimes. All right, so that's going to be this Thursday. I look forward to it. Thank you, everybody, for joining us. And maybe there might even... Oh, David, I wanted to say one last thing to you, and that is, so I did a room yesterday. I just popped it up because I was like, hey, I wanted to make some comments to Paige in his room on after Monday Night Domain. He didn't let me up on stage. He didn't see me apparently. But I did a pop-up room, and people really like to have these open domain conversations in the evenings. So like maybe 4 p.m. Eastern, 4 p.m. Pacific, 5 p.m. Pacific, which was like 7 or 8 o'clock for you, David. I bring it up because, David, I know sometimes you're up for it. So consider you opening up a pop-up sometime, 7, 8 p.m. your time, and I'd like to be in there and badger you. But anyway, I was just saying so I don't have to do it. So I really enjoyed it, and basically there's no format, no outline, and anything goes. So I hope we see more rooms like that because it is fun talking domains. Listen, we all want to make money doing this, and we try to stick to legal stuff here, but it is fun talking about domain investing, trends, and how can we turn these domain names into revenue. All right, I'm done. I appreciate everybody being here. Have a great rest of the day wherever you're at.